You can have your car taken from you without a trial. You can have your cash taken too. And you don't even have to be charged with a crime. In fact, the courts say this is okay precisely because you aren't being charged with a crime. Your cash, your car, they're guilty, not you. They're the offender. And I'll show you where this came from and how it made its way to America and how it can happen to you by simply making a lane change on the interstate. I'll do all this by simply telling you a few stories, with the first one being about a police officer who smells marijuana but instead finds cash. And I'll also tell you the origin story of all of this, which came from a king deciding what needed to be given to God, but quietly reaping the rewards for himself every time. September 20th, 2024. Oklahoma Highway Patrol pulls over Jabrian Harden for an illegal lane change. The officer smells marijuana, searches the car, finds thousands in cash. Harden explains it's from a legal settlement with a vaping company. He doesn't trust the banks. He has documentation. The officer takes the money, takes his phone too. The state of Oklahoma files paperwork, not against Jabrian Harden, against the money itself. And the case name? State of Oklahoma versus $62,650 in U.S. currency. The money is the defendant. But this isn't new. For centuries, English law allowed the government to charge objects with crime. A rope, a cart, a ship, money. The object is guilty, and the owner has to prove its innocence. London, 1336. A sailor named Elias Ide climbs the mast of a ship called the St. Marie Codge. He's drunk. On the way down, he slips on a rope and falls to his death. A jury examines the case. They stand on the deck. They examine the rope, the rigging Ide used to climb. They measure it. They appraise its value. Their verdict? Neither the ship nor anything belonging on it was moving or being moved except the rope. The rope caused the death. The rope was guilty. They value the rope at 10 shillings, enough to buy a cow. The ship's owner, William Hansard, appeals. The verdict gets worse. The entire ship is now forfeited. The city of London takes it. The next year, they give it to the king for a battle against France. William Hansard loses his ship because a drunk sailor fell. He wasn't on board. He didn't tie the knots. He didn't serve Ide the ale. The rope was guilty. Therefore, the ship was guilty. Medieval England called this deodin, a thing given to God. They abolished it in 1846. America kept the mechanism, moved it from ships to highways, from maritime trade to traffic stops. Today, it takes more property from Americans than burglars do. So how did a medieval practice cross the Atlantic, survive the Revolution, and become the system that took Jabrian Harden's money? For that answer, we have to visit a forest in medieval England and the scene of a tragic accident. England, 1275. William Le Roter sends his servant to collect brushwood in Middlewood Forest. The servant loads the cart. Too much wood. The cart breaks open. The wood spills out and overwhelms him. He dies. The local sheriff seizes William's cart and horses. Value, 33 shillings and 1 penny. Why? The cart killed someone. Under English law, the cart is guilty. It must be forfeited to the crown. William petitions the king. He has a wife and children. Without the cart and horses, they can't haul goods. They can't work. They'll starve. September 3rd, 1275. The king, Edward I, orders the cart and horses returned. But William had to beg. He had to explain his poverty. He had to wait for mercy. The cart was guilty, but he had to prove he deserved an exception. In this case, the cart did have a direct impact on the man's death. But sometimes an item just had to be nearby, or rather just valuable, to justify seizing it. And the story about a man who sewed something into his shirt shows this all too clearly. Boston, England, 1313. Nicholas Deval, a merchant from Caen, is selling goods in Boston, England. He wants to send £50 home to his wife in France. He doesn't trust the roads. Highway robbery is common, so he sews the coins into the lining of a linen shirt. His servant, Simon Basil, puts on the shirt and travels at night. Crossing the river Little at Littleport, he loses his footing in the dark and drowns. The Bishop of Ely's officials find the body the next morning. They perform the inquest. They find the money sewn into the shirt. The coins are heavy, they say. The weight surely must have pulled Simon down. The money caused his death. They declare the money deodin, The bishop seizes it, all 50 pounds worth. Nicholas petitions the king, King Edward II. An inquest proves the money belonged to Nicholas, not Simon. November 28, 1313, the king orders the bishop to return it, but the king compensates the bishop for his loss. Even when the owner wins, the crown gets paid, in this case, with influence. The king was magnanimous. He used his power to give money back to the family, and the family was grateful. And the bishop? He still received money. The king made sure of it. The bishop saw the king as someone who would support his interests. Giving to God seemed to have been giving more power to the king. But there was a time when the money didn't always go to the king. And in fact, that time was when the king played no role in those matters at all. Before 1066, animals and objects that caused death were called banes, the slayer. They were handed over directly to the victim's family, not as compensation for the loss, as a ransom to prevent revenge killings, to stop the blood feud before it started. A farmer's ox gores a neighbor. The ox, the bane, goes to the victim's kin. They keep it or sell it. The loss stays within the community. But then came William the Conqueror. After 1066, serious offenses were punished by hanging or mutilation, and fines paid for serious offenses now went to the king rather than the victim's family. The same shift happened to the bane. By the 1200s, the practice has a new name, deodin, from the Latin deodandum, to be given to God. The principle? The object that caused death must be forfeited for the soul of the deceased. In practice, to God means to the church, or to the crown, or to the local lords who bought the right to collect deodins in their territory. The bishop's officials who seized Nicholas Duval's 50 pounds, they declared the money caused death because, in doing so, the bishop could lay claim to it. It was piety, and it was also revenue. The victim's family got nothing. But eventually, grumbling about this practice would come from others than just English peasants. By the late 1300s, English merchants and ship owners are demanding Parliament stop this. The Hanseatic League, powerful foreign merchants controlling Baltic trade, petitioned Parliament about a ship called the Friedland. The Friedland, a Hanseatic ship, anchors at Great Yarmouth. During the night, men in a small boat floating nearby run into the ship's anchor cable. They drown. The merchants aboard the Friedland are asleep. They know nothing about it. They wake to find their ship seized. The Hanseatic merchants protest. This practice exists nowhere else in Europe. It's bizarre. It's destructive. The League has power. England needs their trade. Parliament investigates and rules in favor of the Friedland. The ship is returned. But Parliament doesn't abolish deodin. There's another petition the same year. Flat-bottom boats on the Thames are being seized as deodin. So no one dares to make flat-bottom boats anymore. Food prices are rising because goods can't be transported. The crown refuses to stop. 1377, 1381, 1399, merchants petition, ship owners petition, foreign traders petition. Parliament does nothing. For 450 years, nothing changes. Things are given to God, with the king determining what that means. And individuals have to appeal to the king's good graces to get those things back. Sometimes the king was generous, and sometimes he said no. But eventually, something forces England to have a change of heart. Christmas Eve, 1841, sodding cutting England. Heavy rain has saturated the soil. A Great Western Railway train leaves Paddington at 4:30 a.m. Third-class passengers, chiefly of the poorer class, riding in open carriages. The locomotive is named Hecla. Just before 7 a.m., the train hits a landslip. Soil covers the track. The engine derails. The passenger carriages are crushed. 8 passengers die at the scene. 1 more dies days later. The coroner's inquest finds accidental death and a deodin of 1,000 pounds on the locomotive Hecla by name, plus additional amounts for the railway trucks. Total, 1,100 pounds. A fortune at that time. The company appeals. The deodin is quashed on technicalities. But Parliament is paying attention now. By the 1840s, English reformers are calling deodin exactly what it was. Medieval nonsense. A superstitious relic incompatible with modern commerce. The Lord Chancellor calls it pregnant with absurdity. August 11, 1846, Parliament abolishes deodin. Merchants had petitioned for 450 years. Shipowners had petitioned. Foreign traders had petitioned. A railway company in England faced losses, and within 5 years the practice was gone. Parliament didn't protect merchants' carts. Parliament didn't protect Hanseatic ships. Parliament didn't protect Thames boats. Parliament did protect railway capital. But the legal fiction that made Deodin possible didn't die with Deodin, because it was already crossing the ocean in a different form. The king's peace had a price. On land, if a cart killed a man, if a rope caused a sailor to fall, if money sewn in a shirt pulled a servant underwater, the object had breached the king's peace. The coroner would come. He'd value the object, the crown would collect. At sea, the same logic applied. In 1360, Edward III appointed Sir John de Beauchamp as the first admiral of the English fleets. The admiral's court would keep the king's peace on the high seas, the same peace the coroners were keeping on land. The Black Book of the Admiralty, the founding document of English admiralty law, lists the admiral's rightful profits: prize captured at sea, forfeited vessels, wreck, and Deodins. Same category, same list, same principle. A ship where a man was on board and killed could be declared Deodin, just like a cart on land. That coroner who declared the cart guilty in 1275 was doing the same exact thing that an admiral was doing when he declared a ship guilty in 1375. One stood on a road in Yorkshire, one stood on a deck in Southampton, and both were enforcing the same principle: the object is guilty. The owner must prove that object is innocent. Academics say admiralty, forfeiture, and Deodin developed independently, but the records and the practice seem to show differently. By the mid-14th century, the admiral was already collecting Deodins as one of his profits. The king didn't need a new statute. He simply granted to his admiral the same rights the coroners were already collecting on land. Eventually, Deodin, the word itself, disappeared within admiralty courts, but not the power. England passes the first Navigation Act in 1651. The Commonwealth under Oliver Cromwell wants to break Dutch control of shipping. The goal? All trade with English colonies must flow through English ships, English ports. Cut out the Dutch. Control colonial commerce. The enforcement mechanism? Forfeiture. Ships carrying goods in violation of the act? They're forfeited. Cargo? Forfeited. The procedure? Vice Admiralty courts. No juries. They call the process in rem, against the ship itself. 1660, 1663, 1696, Parliament expands the acts. Tighter restrictions, harsher forfeitures. In 1697, Vice Admiralty courts are established in the American colonies, specifically to enforce the Navigation Acts. The colonists are now exposed to this. Ships are being seized for technical violations of complex trade rules. No jury. Property is the defendant. Burden on the owner to prove the ship is innocent. Same legal fiction as Deodin. The object is guilty. But now it's about commerce, not death. But still with the same effect. The rewards go to the king. The revenue flows to the crown. Boston Harbor, June 10th, 1768. John Hancock owns a sloop called the Liberty. She's just arrived from Madeira with a cargo of wine. British customs officials board her. They allege Hancock's men locked a customs officer in the cabin while they unloaded wine without paying duties, evading the Townshend Acts. The penalty isn't a fine, it's forfeiture. Marines from HMS Romney, a 50-gun warship stationed in the harbor to police the Navigation Acts, row out to the Liberty. They expel the crew. They mark the ship as property of the king. Hancock doesn't get a jury. The case goes to Vice Admiralty Court. The ship is the defendant. A riot breaks out. 2 customs officials are beaten by the crowd and forced into hiding. The British file 2 cases. One against the ship, in rem, one against Hancock, personally, for £9,000. Triple the value of the allegedly smuggled goods. Hancock hires a lawyer, John Adams. Adams mounts a defense that goes beyond the facts. He argues the statute is illegal. 2 defects, he declares. First, Hancock never consented to it. Not through his own vote, not through any actual representative. Second, the penalties are recovered in Admiralty Court. No jury. Hancock is deprived of a right that Englishmen accused of the same offense in England would have, trial by jury. The case drags on for months. Then, in March 1796, the Crown's case collapses. The prosecutor moves to withdraw the charges, but the Liberty is already gone. The Vice Admiralty Court condemned the ship months earlier. The Crown refitted her in Rhode Island, renamed her HMS Liberty, put her to work patrolling for customs violations, using Hancock's own ship to seize other merchants' goods. The people in Newport, Rhode Island has had enough. July 19, 1769, a mob boards the Liberty, cuts her mooring lines, and lets her drift toward shore. They cut down her masts, throw her guns overboard, and set the ship on fire. One of the first acts of open defiance against the Crown by American colonists. 4 years before the Tea Party. But the case was about more than just a ship, and the colonists living in America would make that known. Adams called them the heart and lungs of liberty, representative government, trial by jury. Without them, he wrote, we have no other fortification against being ridden like horses, fleeced like sheep, worked like cattle, and fed and clothed like swine and hounds. Adams lost the Liberty case, but his arguments didn't die with the ship. The First Continental Congress lists its grievances against Britain, among them extending the powers of the Admiralty courts beyond their ancient limits, depriving the American subjects of trial by jury. The Declaration of Independence charged King George with depriving us, in many cases, of the benefits of trial by jury. The Constitution that American citizens create bans bills of attainder, legislative acts declaring someone guilty and forfeiting their property. No more lists of names, no more legislative confiscation. Then came the Bill of Rights. Fifth Amendment, no person shall be deprived of life, liberty, or property without due process of law. The Seventh Amendment, in suits at common law, where the value in controversy exceeds $20, the right of trial by jury shall be preserved. John Adams had two arguments against the liberty seizure: no consent, no jury. And those two things ended up becoming part of the Constitution. The Constitution was now supposed to protect against that principle that started with carts in medieval England, that moved from coroners to admirals, that crossed the Atlantic in vice admiralty courts, that ended up taking John Hancock's ship in Boston Harbor. The Constitution was meant to end all of that. That principle, the idea of a government being able to take your things without due process, it now had constitutional limits, or so they thought. New York, 1779. The state passes the Forfeiture Act. It lists those that remained loyal to the crown during the Revolution by name. 59 of them. Their property, land, houses, goods, is declared forfeited to the state. Commissioners are appointed to seize and sell it. James Leonard is on the list. His upstate property is taken. Later, while in British-occupied New York City, he buys a house. After the war, New York's commissioners come for that house too. They sell it to Anthony Post. Leonard hires a lawyer, Alexander Hamilton. Hamilton is 29 years old. He's building a practice in New York. Defending Loyalist property becomes an important part of it. The Leonard case is straightforward. The 1779 Forfeiture Act declared Leonard's property forfeited, but Leonard bought the New York City house in 1781, after the forfeiture judgment in 1780. Hamilton argues the act doesn't cover property Leonard acquired after the judgment. The court agrees. Leonard keeps the house and gets damages, about 31 pounds. Hamilton represents upwards of 70 loyalists. Many are wealthy merchants. Hamilton believes the new nation needs their capital, but he also believes in procedure, in limits. Years later, he'll say ending confiscation and banishment was crucial for the social stability of the nation and for the restoration of the rule of law. The Constitution reflects this. Article 1, Section 9, no bill of attainder shall be passed. The federal government can't do what New York did to James Leonard, but forfeiture itself survives. And surprisingly, Hamilton would bring it into federal law. September 11, 1789. Alexander Hamilton becomes the first Secretary of the Treasury. The new government is broke. It fought a war on credit. Congress needs revenue, and they need it fast. July 4, 1789, the Tariff Act. Then July 31st, the Collection Act, how to enforce those duties. Sections 12, 29, and 36 contain the forfeiture provisions. Some of those details: if you remove goods from a wharf before they're weighed, those goods are forfeited. Unload those goods at night or without a permit. If the goods are worth at least $400, the vessel forfeited too. The procedure: seizure and libel, leading to condemnation. Pure admiralty language, the same language from British vice admiralty courts. Hamilton has channeled forfeiture into customs enforcement, but it's focused. Maritime trade, foreign commerce, outward facing, away from internal political punishment. But he immediately sees the danger. Within months, Hamilton receives a petition from Christopher Sadler, a mariner from Nova Scotia. Sadler's vessel and cargo had been seized in Boston for violating the impost law. Sadler was wholly ignorant of the law, he says. Hamilton investigates. On January 19, 1790, he reports to Congress. He writes that the government's broad seizure power risks heavy and ruinous forfeitures, imposed for violations arising from inadvertence and want of information, rather than intent to defraud. He argues that a discretionary power of granting relief is indispensable. Congress agrees, and they pass the Remission Act. The Treasury Secretary can restore seized property when violations were unintentional. Hamilton uses this power generously. Research shows Treasury secretaries returned property to owners in 91% of petitions between 1789 and 1807. On paper, strict liability forfeiture. In practice, Hamilton's mercy valve. He's built containment. No more political forfeitures like New York's Loyalist confiscations. But forfeiture nonetheless, although limited to commerce and maritime law. And when it hits innocent people, the Secretary of the Treasury can fix it. Forfeiture is confined. Mercy is available. Constitutional limits are in place. Hamilton thinks he's contained it, but mechanisms don't stay confined forever, especially when you're dealing with money. Alexander Hamilton kept forfeiture confined, within certain bounds, maritime law. And he also controlled a mercy valve, controlled by the Treasury Secretary. For decades, the walls held. But eventually, a civil war would demolish those walls. Congress passes the Confiscation Acts in the 1860s. Property used to aid the rebellion can be seized. Land, goods. Forfeiture moves from ports to plantations, from customs violations to political loyalty. The war ends, but the legal architecture remains, as well as the precedents and the memory of those procedures. Forfeiture on land crops up again in another war, but this time a war against liquor. Prohibition comes in the 1920s, not just a law, but a constitutional amendment. Vehicles transporting illegal liquor, the car is guilty, the truck is guilty. Forfeiture moves from ships to roads. The principle expands again, not just vessels in harbors, but automobiles on highways. Each expansion has its justification. Each crisis has its necessity. And after each crisis passes, the expanded power remains. In 1984, Congress passes the Comprehensive Crime Control Act. One provision changes everything. Law enforcement agencies can now keep what they seize, or even share it with federal partners who let them keep a cut. Before 1984, forfeiture revenue went to the General Treasury. Seizing property didn't benefit the agency doing the seizing. After 1984, it does. The incentive structure inverts. Forfeiture was supposed to be a tool for enforcing the law. Now enforcing the law is a way to generate forfeiture. Police departments begin funding themselves with seized cash. Task forces are formed specifically to patrol highways where cash might be moving. Some departments become dependent on forfeiture revenue. Hamilton's mercy valve? Disconnected. There's no Treasury Secretary reviewing petitions, returning property in 91% of the cases. The owner has to sue. He has to hire a lawyer, has to prove the property innocent. The same burden William Hansard faced in 1336, the same burden William La Roter faced in 1275. The walls Hamilton built are gone. By 2015, federal civil asset forfeiture takes more property from Americans than burglary does. Not because crime has changed, but because the mechanism designed to fight crime has. Going back to September 20th, 2024, in Oklahoma, Jabrian Hardin wasn't on a ship. He was on a highway. The money wasn't cargo. It was a legal settlement. He had won. State of Oklahoma versus $62,650 in U.S. currency. The money is the defendant. No jury, no criminal charge. The burden was on Hardin to prove the money was innocent. Hardin's case took 10 months. A lawsuit, a lawyer, television news coverage. 3 days after that local news channel aired the story, the state agreed to return his money. He got it back, but he had to beg, and he had to do it publicly. He had to explain. He had to wait for mercy. The Fifth Amendment promises no taking of property without due process. The Seventh Amendment promises a jury trial. John Adams called those things the heart and lungs of liberty. Jabrian Hardin didn't get those things. Calling the property guilty avoids accusing a person, and with it avoids the Constitution's protections. At least so says the government. Your things are guilty. As for you, the government would prefer you just sit this one out. That's the end, but before we roll the credits, I need to remind you that what you just watched was the origin of civil asset forfeiture in America. And I did give you a little taste of how it operates in America and how it evolved. The Civil War, United States making drinking beer illegal. But that's just a taste. For the full picture, the story of how civil asset forfeiture moved from admiralty to land was not because of kings. Actually, from our own judges and our own Congress. And I'll tell you that story. But I have to tell you it in a different episode. So I highly suggest you tune in to the companion episode to this one, which is titled, How Civil Asset Forfeiture Took America. Okay, now you can run it. To learn about other quiet mechanisms that can and often do impact your life, and not always for the better, check out my Plain Meaning channel on YouTube for more episodes. And if you watch them all, don't worry, because I release a new one every Tuesday.